Oh, and there was an incident. There was a fight, but I tried my best to de-escalate that situation. But the guy came in my room and stole something from me. So
What happened?
verbal altercations led to that. But that was the only fight I've been in the whole 8 months I've been here. There's multiple other fights that I've tried to de-escalate. I've turned my head from all of them, and the names they call you and stuff. When you don't fight people, it gets to you. But that time somebody took something from me, and I just had enough of it. But that's the only 2 times I've been to the hole, and they held those days over my head from that.
How many days did they hold over your head for that?
It's 30 days.
30 days for what?
For the charge, the in-house charge.
So what do they put you on probation, give you 30 days suspended? What is this?
Yeah, they give you like 5-10 days, and they'll give you 20 days probation, basically. So next time you get in trouble, they'll give you those extra days. So I think that's what they did here. They gave me extra days. Abeyance days is what they call them.
Okay, Nicole, what does it say in your records that he did?
In regards to this instance,
Uh-huh.
the incident report states that he accepted essentially a paper towel-like product that had coffee grounds, and the report states that the pill was in that, and he accepted it.
Was in that?
That is what the report shows. The video shows that.
Well, who wrote the report that says it was in the packet that he put in his pocket?
I have to look at the incident report, but it was written by a CO. The actual video footage shows that the pill was placed.
What was the discipline for the CO who wrote that report?
I don't know. The actual video footage shows Mr. Peck placing the pill on his arm.
Guys, this starts like a routine probation violation, but the defendant's explanation immediately makes the real issue much narrower. What did he actually accept, and what did he knowingly do? That distinction matters because he's already pleaded guilty before the judge starts digging into the underlying incident.
The defendant looking at it, and then Mr. Peck then taking the pill back. He did not take or ingest the pill.
And for that, he got 10 days.
He got 10 days for accepting the contraband in the form of the coffee substance and accepting that.
Do you have a coffee pot in your cell?
No, it's instant coffee, Your Honor.
Instant coffee.
But it was just a little bit of coffee, and I didn't have any, so I took it.
So you got 10 days for coffee.
Correct.
So you didn't complete the jail treatment program.
Well, I had 4 days left. Now, I had Monday, Tuesday,
That's
Wednesday,
not possible.
and Friday.
That can't be possible.
Well, I had
Because
Monday.
you went in, you were sentenced on December 1st to 121 days.
I had 7 days left, but I had 4 classes to
No,
complete.
wait a minute. Because the sentence was 121, the last 30 in the jail treatment program. So 31 in December, 31 in January is 62, 28 in February is 90, 31 in March is 121. So your last day of jail treatment should have been yesterday.
Yes.
So you were in yesterday.
I was in the hole
Right.
yesterday.
So
But-
from the 22nd to the 31st, you were in the hole. So
Yeah.
how could you only did 20 days in jail treatment?
So my counselors, in their exact words, were they thought it wasn't fair to me. That's their words. So they brought me my last 4 packets I had to complete. They brought them to the hole.
Well, then why did they, go ahead, keep talking.
I completed the packets, turned them in the next day, and they said that, I don't know if it'll matter, but it'll at the least show you that I did complete the program.
Then you weren't negatively discharged. Was he negatively discharged, or did he complete the program?
Not physically there. and he did not complete the program.
But you don't need to be there to complete the program, apparently. This is an alien concept to me. Okay? 30 days, but you don't really need it to do it 30 days. So is the program about completing packets, or is it about being physically present?
Well, it does help to be in there and talking with the counselor. That's a main part of it, though. It is.
So did they claim he didn't complete the program? Who told you he was negatively discharged?
We contacted Your Honor and advised him of what occurred here with the medication, with the
Right.
discharge, with the 10-day lockdown, advised you of the date of his due to be completion, and asked, should he be discharged?
Well, no.
Because he would not be present for those days of
Well,
jail
listen.
treatment program.
Listen. So I determined that he was negatively discharged?
We contacted Your Honor based on
Me?
the jail treatment program. Yes,
Me,
yes,
okay? Because he was supposed to be in it the last 30 days.
correct,
He wasn't in it the last 30 days.
correct.
So it's mathematically and physically impossible to complete it if you're not there, if you're supposed to be in it, but you're not in it because you're not there. But apparently it's not, because you can complete it without, so why do myself and the other three typically tell them the last 30 days of your sentence you're to be in the jail treatment program when it really isn't? Doesn't take, how many packets are there to complete?
I think 16.
Okay, so you can theoretically do 16 in one day, completed. Is the criteria completion of the packets or completion of the 30-day program?
Here's the problem for the defendant. Once his disciplinary history comes into view, this stops being a perfectly clean story. The judge learns there were earlier incidents carrying suspended disciplinary time, including visitation trouble and a fight.
You would get nothing out of the program by doing 16 packets in your cell.
How many packets did you do by yourself?
4.
So how many packets can you complete by yourself to get enough to complete the program? Is there a number that they use that says you got to be present for X? If you're present for X number of days and complete Y number of packets for yourself, then that's okay. That
No, I think they were looking at this on an individual basis, and I think based on his prior performance in the program, they were allowing him to work on these packets based on how he had participated prior. Had he not participated fully, they probably would not have reached out to him,
well,
and
this sounds a little crazy to me. But it also seems crazy that he got 10 days in the hole. And especially when he didn't take the pill in the coffee that he put in his pocket. So now what? Now what am I supposed to do? What's your recommendation that I do?
his belongings are here. He has a bed available still at NeoCap. They are able to transport him tomorrow. Do I think he should have removed himself from the situation and spoke up and not accepted the original contraband? Yes, that probably would have been in his
Well,
best interest.
it's but it seems like the bugaboo here was the, what they say was the acceptance of the medication, which didn't occur apparently.
But he also accepted contraband in any form.
What if inmate Peck had given him a piece of paper? It was that inmate Peck took from his cell, brought it to this gentleman, and gave it to him, would that be contraband? What if he gave him a pen? What about a piece of bubble gum? What's contraband?
Those are their rules and their discretion, but I do believe when he's concealing it on his person, it then becomes.
Well, what do they say he did with the coffee?
He put it in his pocket,
I thought it said he put it inside his shirt.
inside his shirt pocket.
Okay. Where did Peck get the coffee from?
I'm assuming his pod,
His what?
his pod that he was in.
What's going on, Edwin?
Couldn't tell you, Your Honor.
Ms. Tomasic?
Your Honor, I spoke with Joseph, and I do have a letter from law inspector, or an email from law inspector from JTP indicating that Joseph did complete the remaining 4 packets. He was close to graduating. I don't know if they actually allowed him to graduate considering he wasn't physically there, but he did take it seriously, did complete the packets. I spoke with Joseph. He said his next step was supposed to be NeoCap.
The tension here comes from institutional confusion, rather than anything the defendant says. The court believed the requirement meant 30 actual days in the program. Staff appear to be describing something more flexible, where strong prior participation can justify completing remaining packets outside the classroom.
When I spoke to him, he seemed very excited to start NeoCap, so we would just ask the court to allow him to go to NeoCap tomorrow while that is available.
All right.
And I'm sorry, just one more thing, Your Honor. If you do want him to actually complete JTP, they're more than happy to take him back as well, they indicated. Thank you.
But he's already completed it.
I think he did complete it for the most part, Your Honor, yes.
No, they say he completed it.
That's what it seems like.
So why would we have him
But-
do it again if he completed it?
They just indicated they are happy to take him back.
All right, I'm going to vacate your guilty plea for the probation violation and dismiss the probation violation. So you will take the next step and go to NeoCap starting tomorrow. Now, I guess we talked about some changeover of the jail treatment program, Ms. Randazzo, coming up. Can you ask the operators of that program to provide us with a working definition of what it means to complete, what the actual physical presence is required versus homework and other stuff like that, because I don't know what to make of this, because I have a fundamental misunderstanding of what it takes to complete that program. And you guys, or they need to inform.
At this point, the judge is openly wrestling with proportionality. 10 days in lockdown sounds very different once the video apparently undermines the medication allegation that helped trigger the situation. Still, the coffee remains a rule violation, and the court isn't pretending otherwise. The sharper question becomes whether that lesser conduct reasonably justifies everything that followed. The judge starts testing the boundaries of contraband with ordinary examples, which exposes how broad the rule might be if anything transferred between inmates automatically qualifies. That doesn't mean jail officials can't enforce strict rules. They obviously can. But when those rules create consequences in a separate probation case, precision becomes critical. The court needs to know exactly what happened and exactly what rule was violated. By the time the judge asks what's going on, the frustration seems directed less at one person than at a process producing unclear answers. Defense counsel now brings in something the defendant badly needs: independent confirmation from the treatment program. The email supports that he completed the 4 remaining packets and had been close to graduating. That doesn't completely resolve the attendance question. but it strengthens the argument that he was taking the program seriously rather than abandoning it. There's also a practical alternative ready to go. He has a bed available at NeoCap and transportation can happen immediately. That matters, because sentencing decisions often become clearer when the court has a concrete next step instead of choosing between punishment and nothing. Then comes the strange part. Staff are apparently willing to take him back into the treatment program, even though they also seem to recognize substantial completion. The judge immediately spots that tension. Why repeat something that may already have been completed? That question puts the entire violation theory under pressure. This is the payoff to all that careful questioning. The judge vacates the guilty plea on the probation violation and dismisses it, then allows the defendant to move forward to NeoCap. What makes this especially important is that the court doesn't treat the confusion as merely this defendant's problem. The judge asks for a working definition of what completing the jail treatment program actually requires, including physical presence versus independent coursework. That tells you the hearing exposed a systems issue. A court can't consistently enforce a program condition if the people administering it and the judge imposing it don't share the same definition of completion. The defendant benefits here, but the broader consequence is procedural clarity for future cases. And that final admission that the situation blindsided the court explains why the hearing changed direction. Once the underlying facts and program rules were tested, the original violation no longer looked nearly as straightforward.